So we're back at ABI's Use in the Bench at Georgetown University Law Center, talking now with Basta from Paul Weiss in New York, who's just moderated a very lively panel about third-party releases in bankruptcy, particularly non-consensual third-party releases and what the issues are there. So Paul, let's sort of tee up a scenario where these sorts of issues come up. So we know releases are very important to the bankruptcy process and to the reorganization of companies. But some courts of appeals have not been as hospitable to third-party releases, particularly non-consensual third-party releases. So the question becomes one that you raised right at the outset as someone who represents debtors and decides where to place the case. How do you know at that early stage which court might be more hospitable to the idea of non-consensual third-party releases?
You know, I think that non-consensual third-party releases are just one part of the mix in terms of assessing what is the jurisdiction or what's the court where you're going to have the most success. And normally when we would represent a company, we would do our diligence on the company. We would identify, it could be 10, 15 legal issues that are going to be important in the case. We would then create a matrix and sort of say, this issue would likely go this way and that issue would go the other way. For example, you know, if the company has trademarks or intellectual property rights, whether you're in an actual or hypothetical jurisdiction would be really matter. If you have labor issues, whether you're in the Second Circuit or you're in the Third Circuit and you're dealing with collective bargaining agreements. And I'd say third-party releases are just one factor. I think it really depends upon the facts of the case. The very first thing we would do would say, are there any third-party claims we even care about? In some instances, it's not even a driver. If we think it is going to be a driver, we always have our looking ahead to say we want to try to achieve as much consensus as we can. And if we can obtain a settlement, is it a jurisdiction that we think we can actually have the settlement approved in?
What do you do in the case where the claims really come out of nowhere?
I don't. In my experience, it's extremely rare that an unknown claim will appear.
So it's not like Supreme Court confirmation hearings, in other words.
Exactly. I think it's if it's something that really needs to be addressed as part and parcel of the reorganization, it's almost always something that is raised with us or becomes known through our investigation of the company.
Thanks. Thanks very much, Paul, for a great panel.
Great.
And we'll be back after the next panel at ABI's Using the Bench.